Ladies and gentlemen, the event will now begin. Kelly, please go ahead.
Hello, everyone. My name is Kelly Nash, and welcome to today's webcast, Inside the Mind of a Mediator, Avoiding Impasse and Maximizing Outcomes in Mediation. This event is brought to you by Law.com and sponsored by National Arbitration and Mediation. Before we begin, let's go over some basic housekeeping items about the webcast console. This event is completely interactive and incorporates many of today's social media tools. You can tweet or directly post information to your Facebook and LinkedIn pages right from the console without having to open a new browser. Just scroll along the bottom of the screen and click on the social networking widget of your choice. If you have a question for one of our speakers, please enter it in the Q&A widget on your console. We will get to your question either during the event or during the live Q&A at the end, depending on how much time we have. We will answer as many questions as possible, so we invite you to ask away. If we don't get to your question, you may receive an email response after the event. In addition, there are some other customizable functions to be aware of. Every window you currently see, from the slide window to the Q&A panel, can either be enlarged or collapsed. So please feel free to change the look and feel of your console as it suits you. Also, this event is CLE eligible. CLE has been approved in the states of California, Illinois, New Jersey, and New York only. CLE credit is available for attorneys in the approved jurisdictions, provided that you have viewed this live event for 50 minutes or more. Participants who wish to receive credits for other states must check directly with their CLE board. Within an hour after the presentation, all attendees will receive further instruction via email on how to obtain your CLE. The CLE code will be announced during the presentation. New Jersey and New York attorneys should be sure to retain the code for their records, since they will need to re-enter it in order to download the CLE certificate. The certificate will be available for download 1 week after the event on November 14th. And now for today's topic and the reason you are all here. Mediation resolves most disputes, though some mediations end in impasse. Disappointments can usually be avoided and positive resolutions achieved when advocates are armed with knowledge of common mediation pitfalls. It's also important to develop negotiation skills that can enhance mediation outcomes. Here to cover key issues in dispute resolution and how to avoid impasse are the Honorable Peter Skelos, Associate Justice of the Appellate Division of the New York State Supreme Court, Second Department, and Hearing Officer at NAM, as well as Michael Emerson, former General Counsel, Signature Bank, and Hearing Officer at NAM. Judge Skelos' experience on the bench, along with time spent in private practice, has given him a broad range of knowledge in numerous areas of the law. In 2019, he was voted a top 10 neutral in the New York Law Journal Best Of survey for the 4th year in a row. And in 2018, he was named a National Law Journal Alternative Dispute Resolution Champion for the 2nd straight year. Michael Emerson served as a U.S. General Counsel and Deputy General Counsel at several of the world's largest financial institutions, including Signature Bank, HSBC, and Credit Suisse. Most recently, he served as General Counsel at Signature Bank, where he was responsible for the legal aspects of the bank, such as litigation and employment matters, as well as transactions. Michael uses his extensive industry experience when mediating and arbitrating in the private ADR forum. So before we dive into today's discussion, we'd like to gather some feedback from the audience by asking 3 polling questions. The first question we have here is it your practice to file a written mediation statement? So please go ahead and make your selection by clicking on one of the radio buttons and hitting submit. And we'll give everyone just a few moments to make their choice before we go ahead and read out the results. And Judge Skelos or Michael, will you have any conjecture as to how people might answer here?
This is Judge Skelos. I think we're going to get an overwhelming response of yes, that people prefer to provide written mediation statements.
All right, great. Well, let's go ahead and see if that is accurate. Yes, we have an overwhelming majority saying yes, 73, just about almost 74%. All right, for the second question, it's somewhat related. We have here, is it your practice to exchange that with your adversary? Once again, we'll give everyone just a few moments to make either selection, yes or no. Okay. And once again, 60% saying yes. Wonderful. And for the third last question, we would like to ask, should the parties be present during the joint sessions? Once again, Judge Skelos or Michael, did you have any idea of how people may respond to this question?
I can tell you what I think the answer should be. It'll be interesting to see if that's borne out, but I strongly believe that the parties should be present with their counsel during the joint sessions.
All right. Yes, 90% are agreeing with that, so that's great news.
Good.
All right, well, great. Thank you to everyone for your input on those questions. Your responses will definitely help to drive our conversation here today. So with that, at this time, I'd like to turn it over to Judge Skelos to go ahead and get us started.
Okay, good afternoon, everyone. Thank you for being here with us. Before we start the meat of our program, the mindset of the mediator and avoiding impasse and maximizing outcome, I think we can all agree that the mindset of the parties and the attorneys is perhaps more important than the mindset of the mediator. And with our polling question number 2, is it your practice to exchange with your adversary? I understand about 60% of you said yes. And quite frankly, I was quite surprised. I'm pleasantly surprised, but I'm quite surprised because that's not my experience in 4 years or so of mediation. But I think that plays right into my opening statement here, that the mindset of the parties and the attorneys is maybe more important, or surely more important than that of the mediator. And I think if it's your practice to exchange your statement, I believe that demonstrates that you are really here, you're attending the mediation for the purposes of having an open dialogue and a discussion for reaching a resolution of your litigation. I think the success at mediation is not accomplished by shutting down the other side or shutting out the other side to get what would perhaps be a litigation win. If that's your objective, or that's your client's objective, then okay, that's your prerogative, but that should be done at trial or by way of arbitration. Those are the paths that you should pursue, because mediation is a means of resolving a dispute. It's a means of mitigating risk. I like to tell people that I'm their neutral risk manager. It's a means of reducing an expense. And for those of you who are involved in mediations involving business disputes as opposed to, let's say, personal injury disputes, it's a means of allowing your client to channel energies to more productive business disputes or even more productive life disputes. So our first slide, as you can see, says, speak to your mediator early and often. And I think it's important in business mediations that are going to take perhaps a day or two, those that are longer than just a couple of hours. I think it's very important that the parties speak with their mediator. They can speak with their mediator in a joint session. I like to have a joint session over the telephone to try to establish some ground rules. But again, folks, because this is not an adversarial circumstance and your mediator is not deciding anything for you, I think you should understand that ex parte communications are okay, but that is something that should be discussed in advance. I have no objection to it as long as we discuss it in advance in our joint session. I encourage the parties to contact me if they have questions that they want to submit to me, or if they want to feel me out on an issue. You can do that by telephone, you can do that by email, and you can have a conversation. You should speak with your mediator early and often. I find that attorneys do not take that opportunity when they should, and the mediator should contact them and encourage them to do that. You can discuss things that range from merely procedural, where is this going to be, who's going to be present, what are the accommodations like, do you have access to video, do you have access to other digital computer hardware and software. You can talk about substantive overviews, the factual and legal issues in the case. You can make arrangements for when the mediation statement is going to be submitted, how long it should be, whether it should be submitted digitally, or if the mediator is an old guy like me who wants a hard copy, then you'll know that the mediator would like a hard copy, something that he or she can touch. And because your mediator should be informed about your case, speaking to your mediator early on and having a conversation that speaks to the procedural and substantive issues allows the mediator to digest and process information. And I think maybe more, perhaps more importantly than that, it allows the mediator, especially if he or she is speaking with counsel who they've not worked with before, it allows the mediator to get a handle on what the mindset of the parties are, what the mindset of the attorneys are. Also, again, going back to our second question in the poll, it allows you to discuss the confidentiality of the submission or whether or not there should be an exchange. We turn to the second page, or I should say the next screen. We have a little caption here. We call it Trust Your Mediator. I think that each and every one of you should vet your mediator before you agree to sitting with that person to oversee the negotiation of the resolution of your client's case. Some of you have maybe used that mediator many times before and you don't really need to do any vetting anymore. But maybe you're participating in this for the first time. You haven't met this person before. You should take the opportunity to vet your mediator by here at NAM. You can discuss that with your account executive, your case administrator. That person can tell you about the mediator's profile, can tell you about the mediator's personality as well. And you should also vet that from truly a neutral source, which would be your colleagues who may have had a prior experience with the mediator. Even if the case did not settle, the mediator may still have helped the parties come a little bit closer together. So you would want to know from your colleagues a little bit more about your mediator. When we say trust your mediator, I think it's important for you to remember the mediator is a neutral person. The mediator is not judgmental. The mediator is objective. And you should allow the mediator, who again, although not judgmental, the mediator can help assess the highs and lows of your case. We can do that, again, as we mentioned before, with proper submissions. This makes your mediator a knowledgeable participant. And of course, the timeliness of the exchange is important. So we don't want submissions that are coming in 15 minutes before the mediation is about to start. That's why it's a good thing to discuss the procedural aspects with your mediator so that we can have a timely submission and timely exchange. Remember that your mediator has a job to do. That mediator's job is to help you fashion a resolution for your litigation. The mediator only gets more work if he or she develops relationships of trust and gets the job done. Allow your mediator the opportunity to develop that relationship with you. So you should work with and trust your mediator to help you fashion a resolution of your case. What about the next slide we'll go to is the one that says, know before you go. We can also call that one, you have homework to do. And your homework is not only in your office, but it's your homework with respect to the other side. And that is to make sure that everybody has the necessary information that they need to participate in a full and open, sincere, and reasonable dialogue. There has to be good faith disclosure. Good faith disclosure will prevent mediation from being sabotaged before the real negotiations start. So, of course, everybody wants to know what the offers and the demands are, okay? And many times before we start our mediations here, the parties have had those types of discussions. Sometimes, unfortunately, the plaintiff may change the demand to a higher number, or the defendant may change the offer to a lower number. And if that's only coming on board after we start the mediation, if we only learn about that after we start the mediation, that can really create a non-starter situation, or it can create a circumstance where we're going to have to spend 15 minutes or a half hour overcoming a hurdle that was not necessary. If you have to change your offer or you have to change your demand because there's new evidence that substantially strengthens your claim or strengthens your defense and will affect the opposing party's evaluation of the case, you should not wait until the last minute to make that change. People come to mediations with what they believe is an understanding of the other side's monetary position, and they should be able to rely on the word of their adversary before they come to the mediation. Another issue that needs to be done and can be done during the course of the early conversations with the mediator is who will be in attendance at the mediation. You need a decision maker there. A decision maker has to be present. Because we know that people are all over the country these days, if the decision maker cannot be physically present, one of the things that you can discuss early on with the mediator is the inability of that person to be present and the question of whether or not there is video conferencing capability. It's very important that the decision maker be in the room. I know for me, when I'm evaluating where I can go with the parties that I'm dealing with and the attorneys that I'm dealing with, face-to-face, FaceTime contact is very important. Another issue that's related to who will be in attendance at the mediation is the mediator needs to know if there is some kind of animosity between the parties such that they should not be in the same room. All right? If that be the case, you should let your mediator know about that up front, and arrangements will be made so that they don't cross each other's path. Another issue that should be discussed up front and something that fits within the know before you go is if this is a matter that has insurance coverage or there's a question of insurance coverage, then the issues of coverage and issues of reservation of rights, disclaimer, or whether there's a self-insured retainer, or if this is one of those eroding policies and how much is left on the policy, This should all be resolved up front, and it should see the light of day before you commence mediation. Another item that fits in the know before you go, and again can be handled at the outset of the case, is the question of whether or not there's any outstanding discovery. It's important to know this because if there is open discovery that will prevent a meaningful dialogue on your case, then maybe the mediation should be adjourned until that matter is closed out. Another item, and this is something that I've encountered all too many times, is with a lack of preparation, sometimes the parties really don't know what their demand is going to be. They don't know what their offer is going to be. They don't know what the range is going to be. In my view, if you have a discussion with your client in advance of the mediation and educate your client about the process, and you're fully advised and informed of the case, then I think you'll know what your client's tolerance level is. And you should be able to, whether they're demands or whether they're offers, you should be able to have a range for each round of the exchange of demands and offers, and know that your offer or your demand from one round to the next is going to be within a range, so that there's not a half hour or 15 or 20 minutes of cogitation on what the next number should be. One of the important things in mediation is momentum, and if you lose momentum, then sometimes the process gets mired. I'll turn it over to Mike to speak with the next slide.
Okay, thank you, Peter. So we're going to talk about preparing the mediation brief. And just going back to the early questions, it looks like 70% indicated that they do file a written mediation statement, and a slightly less percentage, 60%, actually share those with their adversaries. As a general rule, I would always support preparing a mediation brief or statement. Among other things, this is your opportunity to tell your story in an uninterrupted way. So you should be as persuasive as you like, but importantly, you really need to keep it factually. There's no sense in misrepresenting things because the other side will likely call you on it, and this would likely create bad feelings and distrust. So use the brief to educate both the mediator and your adversary as to your position in advance of the mediation. The bottom line, as we know, is that the objective is to reach an agreement. And objectively, this requires full disclosure of the facts. So there's no point in withholding information. It will simply delay and potentially derail the resolution of the matter. So use the brief to maximize your use of time and to avoid lengthy arguments during the joint session. Again, much better to get things out in the open early on rather than creating surprises during your actual mediation session. So get everything you can on the table in advance, and if each party is approaching the mediation in good faith, where the goal is to resolve the matter, then disclose as much as possible. Avoid surprises or doing things that will annoy the other party or use up time unnecessarily. And as I said before, keep it factual and keep it relevant. Now, I would advocate to always exchange the brief with your adversary. And there is a practice of keeping certain information for the mediator's eyes only, but that shouldn't necessitate withholding the brief altogether. And I think it's to both sides' advantage to share as much information as possible as early in the process as you can, because that will avoid a lot of unnecessary interference during the mediation session itself. And as I said, you can exclude from the brief any materials which you believe should be withheld for tactical reasons, and that information can be shared solely with the mediator. So remember, this is a negotiation. And I think it's important to share as much information as possible in advance. So just a couple of other points on this. I think anything not previously disclosed by way of the mediation statement will likely need to be disclosed during the mediation itself. This could occur in response to a question or information that needs to be disclosed in order to make other disclosures make sense. And think about all that could impact the success of the mediation when you're thinking about what to disclose and what not to. Just to continue on to the next page. As suggested, submit an accurate, brief, and clear summary of your position. This is not a throwaway effort. Use this to the best of your ability. It is worth the time and the attention to do so, and it can have an impact on the other party. Address the procedural status of the case, the basic facts and your arguments in support of your position, including the applicable law. Lay the groundwork appropriately for why you are in the mediation. Is it to resolve everything, or are you there simply to resolve subset of particular areas or issues that need resolution to make the mediation successful? This can often occur if there's a companion litigation ongoing and there's a mediation set up to resolve less than all of the issues. Avoid redundancy. Less is more, and get to the point. And feel free to attach exhibits which are critical to your case. The mediation brief is the principal tool used for the how and what to tell the mediator in advance of your session. A well-prepared mediation brief will reflect well on your lawyer and your position. It's an opportunity to impress the mediator. And submit the brief well in advance. It shows that you are prepared, that you're considerate, and that you're confident in your position. All right, let's go to the next slide, opening statements. Don't pass up the opportunity to make an opening statement. Some practitioners look to bypass opening statements, thinking that they've heard it all before. But remember, the opening statement will clearly set the stage. It should provide an update as to what the parties and the mediator should expect to discuss and deal with. The bottom line, bypassing the opening statement solely to opposing counsel might be acceptable. But remember that the mediator and the adversary's client need to be considered. And don't underestimate how ears less familiar with the details of the case might hear broader themes and issues. How something is said, rather than simply what is said, can be critically important. The dynamic of hearing something firsthand can be very revealing. Think of the tone, the emotion, and the seriousness with which things are said. It's a real opportunity to be persuasive and convincing, and it can influence anyone in the room. And opening statements should be tempered by the detail of your mediation statement. So keep it consistent with what your case is about. And also, the failure to provide an opening statement can be interpreted as a lack of commitment to the proceeding, or a lack of confidence in your position, or that you are not taking the mediation proceeding seriously. So these are all things to keep in mind. Let's go to the next slide, absence of decision makers. So what happens if a decision maker for a party does not show up? Judge Skelos mentioned this earlier, where he thinks it's actually a critical factor of any successful mediation to have a decision maker there, ideally in person, but at least remotely if that's all that can be done. So the lack of a living, breathing person to resolve the dispute is always problematic. It's not necessarily fatal, but it does create issues. I think it creates a sense that the party does not view the matter as important, or a priority. Think of other important events and who you would expect to be there for it to be a success. It could be a birthday, a wedding, school graduation. A mediation is really no different. It's critically important that the right people are in the room. Absentee decision makers do not obviously participate in the negotiations in real time, nor can they appreciate the nuances of the situation as it is developing. And decision makers may not receive all information if he or she is not there. This can cause delay or confusion, and it may interfere with the mediation. The logistical hurdles and delays in communication when the decision maker is absent or located remotely serve only to frustrate matters and turn the other side. So the absence of a decision maker is difficult to overlook or ignore, and it can really undermine the entire proceeding. It can also call into question and can effectively undermine the seniority or importance of those who are there. So I'd like to send this back to Kelly just to have her make her CLE announcement.
Excellent. Yes, thank you, Michael. So at this point, we will go ahead and read out the CLE code, which I'm sure everyone is eagerly awaiting. So the CLE code for today is case 7. That's CASE and the number 7. Again, the code is case 7. Thanks. I'll turn it back to you, Michael.
Okay. Actually, over to Peter now.
All right. Thank you. This is Peter Skelos again. Do we want to pull up one of those questions, or are we going to save them for later? Sally, do you want to pull up? There was a question that dealt with, that I saw up on the screen, that dealt with disciplinary matters. Is that, I thought that was an interesting question.
Yeah, absolutely. We have gotten some engagement already from the audience. And that question that we have here is, are these recommendations the same if the mediation is for a client's disciplinary matter, for union or employment-related matters, or are any changes recommended in that instance?
Yeah, so I think that's a good question, and, you know, particularly when we're speaking to disciplinary or grievance matters, those are the types of cases where maybe you want to hold a little something in your pocket, okay, or in your vest. And I see there's another question. How can a written mediation statement be shared with an adversary if you are a neutral? Well, there's three. If it's a two-sided mediation, there's three people who are at the mediation. There's the neutral, that's me, the mediator, I'm the neutral, and then there are the two parties with each other. So if you file your mediation statement, you're sending it to the neutral. If you file and exchange your mediation statement, that means you're sending it a copy to the neutral and you're sending a copy to your adversary. If we can go to the slide that says wearing trial blinders. Okay, and again, this is goes back to what we were saying earlier.
Judge Skelos, if I could just interrupt for just one moment.
Sure.
I apologize. We have someone who it seems was not able to get the CLE code, so I'll go ahead and read it out one more time. The
Sure.
CLE code for today is case 7. That's CASE and the number 7.
Okay, so thank you, Kelly. So at mediation, a win is a resolution, or falling short of that is a pathway to resolution. And I think that what you'll find with your neutral or your mediator is that even if you have not resolved your case, but you have a pathway to a resolution of the case, your mediator will encourage you to stay in touch and will try to help you resolve the case, either by a few telephone calls that go back and forth, or maybe scheduling a continuing or a follow-up session. So that's one of the problems that you would, or that's a resolution, so to speak, that you can't have if you wait to put your case into mediation until the eve of trial. Of course, that's a logistical problem because if you're close to resolving it, but you have a judge who has set a specific trial date, then you can't have a continuing mediation, so you shouldn't wait till the last minute. There's another reason you shouldn't wait till the last minute, and I think that's because if you're waiting till the last minute, you could be put in a box, okay? You could be in the position of you have to settle for a number that you either didn't want to agree to as the plaintiff or you didn't want to offer up as the defendant. You put in a box because the next day is the watershed date rather, and you're out of options at that point. So waiting till the eve of trial, I think, can be detrimental to the process. Also, by the time you're at the eve of trial, I think our experience is that counsel may be in what some of us will call the trial zone, okay? And they're in the trial mantra. And when they're in that trial zone, they're becoming more of a advocate and creating a more of an adversarial circumstance than if this was earlier on in the process and where there was room to negotiate and it wasn't take it or leave it. We're going to trial tomorrow. If both sets of counsel are in that trial zone, or even if only one is in that trial zone, they may have difficulty listening to critiques of their position because they've become more hardened in it. So what do you do if you have a counsel who is kind of hardened in the position and maybe not listening, not as open-minded? I think a good thing to do is to bring in a new attorney, not for the purposes of the trial, but a new attorney who is going to be the lead attorney at the mediation. Again, not to substitute out the other attorney, but just to take a different tact to see if the mediation can be fruitful. So don't wait till the eve of trial. Don't put yourself in a box. And if possible, allow the mediator to remove those trial blinders. Maybe your arms won't be crossed across your chest in a defensive position. Let down your guard a little bit, and as we said early on, trust your mediator. As we indicated before, if we go to the next slide, if possible, bring in someone else. Bring in someone who has some fresh eyes. Maybe what I find is helpful is if you bring in a business person to participate or to lead the mediation. Someone who understands the drain that the litigation is putting on the resources of the business, and someone who understands that a loss here could be detrimental to the business. Allow that opportunity one more time to really concede points, all right, if need be. So that brings us to our next slide. Acknowledging weaknesses in mediation. I think if you acknowledge the weaknesses in your case, whether it be in your verbal discussions with the mediator or in your written statement to the mediator, I know nobody likes to put that in print. That's okay. But if you do that in your oral presentation to the mediator, then it allows you to focus on your strengths. You don't want to be in the position of being defensive. So if you're focusing on weaknesses in your case, I think you've put yourself in a defensive posture, and you should not be. You should be able to focus on the strengths of your case. If you focus too much attention on your weaknesses, that takes away your strong points. It may put you in the position of losing some credibility because you're defending points that really may not be defensible or are less defensible.
Is it fair to say, Judge, that you should at least address the weaknesses rather than try to ignore them? Because I would imagine that the other side is going to know your weaknesses and may try to use that in a way that would disadvantage you during the mediation.
Good question, Mike. I think if you acknowledge your weaknesses and you're prepared to address them, and one of the ways to address them is to suggest that those weaknesses are not on the dispositive issues in your case, and then you move on to the stronger points of your case. And of course, if we turn to the next page, which is slide 15, I'm not suggesting that you disclose weaknesses that are unknown to the other side, but you should at least be able to consider those weaknesses in evaluating the case, because maybe those weaknesses will at some point become known to the other side. If the other side already knows your weak points, then acknowledge those weaknesses cannot hurt you. Addressing them by suggesting that those are not the dispositive issues in the case, and then moving on to your strong points, I think is the better way to handle that. And again, I think that builds, again, mediators are not judgmental, but we can't help but evaluating highs and lows. So if you're defending a weak point, not acknowledging it as one, sometimes that can result in the loss of credibility. Right?
Okay. I'll take it over, and there's actually a question that has come in that I can have you take a look at while I'm moving this forward. So we're going to switch now over to the slide, Overcoming an Impasse, Emotion and Anxiety. So what happens if things get stalled? So mediation is often marked with emotion and anxiety for clients, even for hard-shelled professionals. The dispute may be long-running, contentious, and expensive, and clients may enter a mediation tightly wound and with a short fuse, and generally defensive about admitting or conceding anything. So the mediator needs to keep matters in balance and slowly allow pressure to be released to be able to move the matter forward. Addressing the psychological component, such as a person's feelings, experiences, and emotions, of a mediation is often as critical as the substantive issues, and failure to do so can lead to an unnecessary impasse. So it's important to understand that everyone will likely approach a mediation based on their own experiences and their own understanding of mediation. There is no set approach or experience. Each party will have his or her own expectations, beliefs, and mindsets. This is one of the reasons why I think the one-on-one sessions can be particularly effective at giving each side the opportunity to emote, relax, and regain composure. This can be used effectively to release pressure. Just continuing to the next slide. So both clients and their counsel honestly need the opportunity to vent and complain. If the ability to get things off their chest is not allowed or is blocked by the mediator, catharsis cannot begin. And again, to me, this highlights the importance and the benefit of the one-on-one sessions rather than simply having joint sessions. If this occurs, where people get too emotional and anxious, the mediation may begin to head off the track from its inception and may not be able to recover. Equilibrium needs to be maintained while the pressure is relieved, so that parties can get down to business and engage in negotiations. And it's really oftentimes that the mediation sees its greatest progress towards the end of the session, because people show up and they have their emotions and they have their anxiety and they're defensive, and they're really not willing to concede anything until the mediator in particular can get everybody to calm down, take a deep breath, take a hard look at what's going on, and get to the point where they're willing to see the path forward. So just a couple of other points on this. I think it's important that there is emotional acceptance by each party as much as intellectual acceptance. And at the end of the day, each party must believe that this is the best possible outcome, and each party needs to accept that. And as I just mentioned, there are benefits of the one-on-one sessions rather than simply having joint sessions all the time. The one-on-one sessions give the parties the ability to vent, emote, and behave with the mediator in a way that they wouldn't be comfortable with the other party present. And I think this is really important because it's a break that lets the parties really be who they are and not try to maintain a specific front because they're in front of the other party as well. And these sessions give the parties the ability to disclose information in a way they wouldn't with the other party present, and to say things about the other party in private. And I think what this then requires is that the parties rely on the mediator skills and abilities to present additional information to the other side. Okay, back over to you, Peter.
Yep. Okay, so we have a question up here. It says, do you have specific thoughts on approach to mediation conducted prior to suit being filed? How best to respond to a claim during the mediation that a party needs discovery? I think that's an excellent question, and I think that it underlies the importance and the significance of mediation early on in a case, whether it be during the so-called claim stage or very early on in the case before discovery. So if there's a question of discovery that's needed before there can be fruitful mediation, your mediator can actually help you mediate that discovery dispute. What are the items that are needed? What are the boundaries by that the party from whom discovery is sought is willing to go in providing it? What's the timing of it? And let's come back to have another session after there has been the exchange of that discovery. Let's move on to our next slide, number 18, overcoming an impasse, hardball negotiation tactics, addressing unreasonably high demands and low offers. Good question or a good topic, because I think we know that unreasonably high demands and low offers can often be non-starters. And we see that very often in our practice here. And I think this goes back to the issue we spoke about before, which is trust your mediator. The mediator can get the feeling whether or not those high demands or unreasonably low offers are really going to, even if it's not an impasse, just stall the process. The mediator wants you to be open, wants you to be honest. The mediator will maybe ask you where you want to go with this case, all right? And I always tell the parties that are in front of me, be honest with me. I know you're going to lie. It's okay. Lying a little bit is not being dishonest. So hold a little in your pocket. It's okay. But let up a little bit. Let your hair down a little. Let me see if I can knock numbers off the top and add numbers on the bottom that brings us into a range where we can start to have an open dialogue. On the back end of the mediation, we go to our next question, or our next topic, employing conditional demands and offers. When we get towards the end of the process, the parties are close, but they're not close enough to come to a resolution. And I get it that plaintiffs don't want to give their bottom number, and defendants don't want to give their top number. But you can have the mediator treat this as a mediator proposal. So the mediator will go to the plaintiff and say, look, if I can get you this number, will that be acceptable? Or the mediator can go to the defendant and say, look, if I can get the plaintiff to accept this number, can you go there? So I often allow the parties or ask the parties to allow me to treat those issues as a mediator's proposal. I'm going to suggest to the parties that this is where we go. I'm not going to say to the plaintiff, look, this is the number that the defendant has given, or vice versa. I'm going to say, this is a number that I'm going to suggest that the case could be resolved at. That way, neither party is wedded to the number. Again, we're not judgmental. Trust us to provide an open and objective assessment of your case, but not just of the merits of your case, but an assessment of whether or not the case can be resolved. All right? We know what's going on in the other room. Trust us to help you come to a resolution with that knowledge. Mike?
Okay, so let's talk about some ethical issues and concerns. We'll start with advocacy versus misrepresentation, and I think there's an important distinction here. I see advocacy in its basic terms as really highlighting the strengths of the client's position and perhaps minimizing the weaknesses. Misrepresentation, on the other hand, I think consists of misstating facts and other points and really misleading the other party or its counsel. I think misrepresentation is likely to be called by the other party, who should know the facts as well as you or the other side. You know, is this an evidence of bad faith? I mean, potentially worse. And as I said, I would expect to be called on anything like this. Disclosing your authority and asking the mediator to save you something off that figure. And I think that really risks compromising the objectivity of the mediator and perhaps puts it more in the camp of being an advocate for one party versus the other. I personally don't think it should be done. Peter, you may have a different view on how this comes up and how you deal with it.
Well, I think it goes back to the issue of a range, okay? And it gives a little bit of discretion. I know it can. I don't disagree with your point that it can put the mediator in the position of being an advocate to try to save a couple bucks off for the defendant, or get me a couple of extra bucks for the plaintiff, even though I know I'll settle for $5. See if you can get me $7. I don't disagree with your view of that.
How frequently do you see this?
Enough. I'm not going to say every day, but it happens. It happens, and I think it goes back to the range. And if the case could be resolved within a range, and the range, you know, if we use a Venn diagram, so to speak, and there's an overlap, I think everybody's okay with it.
I have also seen it in the notion of a range. It kind of gets hidden in there a little bit. Just continuing on, discovering a party has committed an error or undervalued their client's case. I think the mediator should address this, and I guess there are a number of different approaches to doing this. I think one thing a mediator should do is set the stage early on and make it clear to the parties what actions are not acceptable and will not be tolerated. Just the last point here, respecting the confidentiality of communications with the mediator. This is critical, and I think the underpinnings of a mediation really depend on this confidentiality being maintained, and I think it will just undermine the whole process if that fails to take place.
Okay, so we're going to, I guess we're going to go to the last slide, and we can, I think I can sum this slide up kind of quickly. You know, when we come to mediation, it's about coming to a resolution of the case, and the big picture items are frequently, what are the dollars on the case, let's say, if it's going to be, if it's a case really involving money as opposed to the resolution of a business issue. So the big picture becomes the money, but sometimes we forget about the nitty-gritty. And the nitty-gritty I'll call things like confidentiality agreements, non-disparagement agreements, payment terms, default terms, and the like. And if these are issues that are important to you and important to your client, then I think you should bring those to the attention of the mediator, and the mediator will bring them the attention of the other side, or you have it in a joint session right up front, because those types of issues may end up trashing a resolution of the case, or you'll hear somebody say, well, if there's going to be a confidentiality agreement, then I want extra dollars for that at the end, and that could trash what was otherwise a resolution of the case. I think we're turning it back to Kelly. Is that correct?
Yes, so we are just about reaching the top of the hour at this point. So at this moment, I'd like to thank Judge Skelos and Michael, of course, for all of your valuable insights here today. And thanks also to Law.com for their support. Thanks to everyone in the audience for making time to join us here. We hope this discussion was useful to you. Just as a reminder, all participants will receive an email shortly after this event with detailed instructions on how to receive your CLE when it becomes available on November 14th. You will also receive an email 1 week from today with instructions on downloading your state-specific CLE certificate. And also, just as a reminder, this webcast will be archived so you can refer to it later if you so choose. So with that said, thank you, and everyone have a great afternoon.